Welcome to IHT Exemptions and Reliefs, what still works and what's under pressure. And my name's Julie Bell. I'm a private client practitioner based in Manchester. Let's see what we're going to cover today. We're going to look at the scope and application of the big guns, the big IHT exemptions and relief, and looking at the residence nil rate band. We're going to look at options we have to maximise the use of exemptions. And sometimes we're going to have limited options depending on the particular client that presents themselves to us and their circumstances, while managing any risks in relation to that. Let's start off by looking at taper relief. And taper relief is really important because it's often very misunderstood by clients. So when we're talking to clients, lots of clients are aware of the 7-year rule that you need to survive 7 years for it to fall outside your IHT calculations on death. But then they start to talk about there being a 3-year rule and 3 years being advantageous. And unfortunately, for the vast majority of gifts, it is a 7-year rule, not a 3-year rule, because the gift is not large enough for it to come within taper relief. So taper relief under Section 7 applies where the transfer has been made more than 3 years before the transferor's death and tax is due on the transfer in its own right. So that's the key bit. Has this gift, this failed pet, now become taxable? So clearly, if I make a gift of £10,000, I've never made any gifts to anybody else before, it's an all or nothing. Have I got to the 7 years? Taper relief is never going to be applicable. If I give a large gift, £1 million, then there are advantages as soon as I can get to that 3-year deadline post-death, and those advantages then increase each year until we get to 7 years and it's fallen outside the IHT calculation. The relief does not apply against tax on immediately chargeable lifetime transfers unless there is a subsequent death, so you die within that 7-year period, and HMRC are then looking to charge additional charges.